Good afternoon. I hope everybody is having a good Thursday. My name's Heather. I'm back to talk to you guys again today about some estate planning things. Again, this is our weekly Ask an Attorney Anything. Of course, feel free to leave any comments down in the box and I'll be happy to answer if I can. And if not, I'll make sure that another attorney gets back to y'all if it's outside my practice area. So again, my name is Heather Ward. I'm our estate planning associate here at the Legacy Legal Team. And I wanted to talk to you today about something that seems counterintuitive, but it's something that I've been running into a lot during my consultations to when people come in and say, I think I'm interested in estate planning, but I don't really know what that means or what I need. Or they come in with complete idea of what they want and they just need somebody that knows the law and knows how to do it. And that issue is people not being upfront and honest with their attorney or potential attorney. Doesn't happen often, at least to an extent to where I can't actually help take care of the person. But when you are scheduled for an estate planning consult, you get some intake paperwork. We'll ask you some questions about yourself, about your spouse or partner if you have one, any children, and then just some general information about your assets. I've had people that come into the meeting and they're like, Heather, you're not even my attorney yet. Like, why are you asking? And it's not even just for me to be nosy. It's because I really try to tailor your appointment to what's going to apply to you. I'll go through some examples of that as we go through this, but I don't want to waste either of our time going through things that I don't think are going to be helpful for you. Of course, if you ask questions about a trust, even though I don't think it's really the best route for you, I'm going to explain that to you. But if I have an idea of walking into that meeting, I can be prepared. I know exactly what things I think I'm going to need to talk about based on that. If you have minor children versus 50-year-old children, your plan's going to look very different. And I can gauge the way that I'm going to talk to you about those things differently as well. If you're a healthy 35-year-old versus a 90-year-old who has a lot of health issues, I'm going to talk to you differently about your plan because those are different goals and different timelines that we're dealing with. So that's really the big reason why I ask, is so that I can tailor your appointment to you. I'm not wasting a bunch of your time explaining things that are never going to apply to you, specifically when it comes to like taxes and stuff like that. But of course, if it does apply to you, or if you ask a question where it's going to go down that line, of course I'm going to answer that. But I do like to tailor all of my appointments to what I think is going to be a good use of all of our time. The other big part of it is I can't help you if I don't know what we're planning for. Again, if you have children that I didn't know about, your plan's going to be wrong because of the way that lawyers speak in their documents. There's certain ways that we have to phrase things, and if you are intentionally disinheriting somebody, we need to know that. You can't just be like, oh yeah, I didn't include them because they're not getting anything. So it's really important to be honest with your attorney, upfront with your attorney. Trust me, I get it. There are a lot of bad lawyers out there. There's a lot of lawyers that are out there for the money and not there for the right reasons. And I will tell you right now, nobody at our firm is that type of attorney. What I always like to tell my clients is I talk to all of my clients like you are my family. I'm not going to sell you on something that I don't think you need. I'm not going to upsell you to a trust just because it's more expensive if it's just going to end up being more difficult, more time consuming, more expensive. That doesn't do anything for me morally or ethically. I don't really care about the money. So when you're coming to meet with an attorney to specifically talk about estate planning, we really want you to be upfront and honest with us, and that starts with filling out your paperwork when you come in to see me. There's really two big pieces of that document, that intake form, which is talking about your family information and about your assets. We'll talk about family because that's a little bit of the easier discussion and where less people get hung up. They just don't realize how important it is to properly fill out that paperwork. Like I said, we're going to ask you some basic information about you and your partner or your spouse if you have one. Name, address, if you own additional properties, especially if it's out of state and we need to plan on some community property aspects from other states, things like that. And then the biggest one for me is your children or your next closest blood relatives if you do not have children. I have come across people that come in and they say, I have one child, and then it turns out after talking to them that they actually have 3 children, but they haven't had contact with the other 2 in 20 years. Yeah, they're not really thinking about them in that context, but where we really see this hung up a lot is us lawyers like to use this phrase called to my descendants' first sturdies. which everybody's like, Heather, what the heck is this? It's essentially a legal phrase that says my kids are going to split equally, and if one of them has died, it goes down to my grandchildren from that line. This is a problem if there's children we didn't know about, because now we have just given them a share without knowing it. We also have the issue where people have a child that has passed and they don't tell us about them. And yes, of course, they're not going to get anything, but if I've used that term, descendants first servties, their children are actually going to get a share, and you may not have intended for that to happen. Just try to be thorough when you're filling out documents. Always err on the side of disclosing more information. Even if you don't want to put that on the form, that is something that you need to make sure your attorney that you're speaking with knows when you're going through things. And then, of course, if you're disinheriting somebody, we're going to talk through what that means to you and the reasoning for it. And it's, again, not because I'm being nosy. I don't care. You can do whatever you want to your stuff. But I'm trying to protect you and the people that come behind you from any sort of argument of saying that somebody unduly influenced you, things like that. Again, I'm going to talk through the hard things with you, and I can't have you saying, well, I don't want to discuss that, because it's hard for me to help you and to help your loved ones if I don't know the reasoning for things. Of course, that all stays confidential. Everything that's on this paperwork is confidential. Everything we talk about is confidential, and it's not going to leave that room. But if the person you disinherit tries to sue and make your will invalid, then we talk about the reason why they were excluded. Excuse me. Your family dynamics and who's involved is also going to affect the type of estate plan that I'm going to recommend usually. For example, like I used earlier, if you have minor children versus mature children that are going to behave responsibly with a lot of money or real estate, those are two different types of plans. If you have primarily real estate, we might do just a ladybird deed, because that's your main asset and we know exactly who it's going to, and they're not going to fight about selling it, and great, that's easy and cheaper and we can go that route. That's not always the case. Same thing with retirement accounts. We have a super easy, simple solution, but usually your retirement account is going to have a lot of money in it, and so if you have a 20-year-old child who legally would be able to take that entire amount out if he's left as that beneficiary designated on there, you may not want your 20-year-old to be able to withdraw $100,000 because probably not going to use it right. Family info really makes a big difference on the way that we word things, the type of documents that we recommend. Another really important thing is how important it is to you. Say, for example, you have 2 children. You want them to split everything equally. What happens if one of them dies? Do you want the other one to just get everything, or do you want it to go down to your grandchildren from that deceased child? Those are things that I like to know ahead of time, because if I don't know that you have grandchildren, I'm not going to talk about a lot of things. Of course, this is a question that I asked in your consult, but again, it helps me prepare, make it a much more efficient and productive meeting, and then we can cover a lot more in your meeting. So that's like the family side of things. I see less of an issue with that than this next piece. But it is important to make sure that you disclose all of that information. But the one that I see a lot of times that people skip on the intake form, and I don't know if it's just because people just don't trust lawyers, which again, I totally get, but I'm not one of those lawyers. But that is your asset information. If you own a house, bank accounts, IRAs, 401ks, CDs, all the things that you can, and the value of those. To me, it's much more important to know the type of assets that you have. If you don't feel comfortable disclosing the value, I'm still going to ask you during your appointment generally how much you think you're worth, because that makes a difference in planning. But especially the types of assets that you have, because if you rent a house, you don't own, and you just have a vehicle and a couple of bank accounts, your plan is going to be severely different than somebody that owns property, because we have to handle those things differently. So really make sure that you're disclosing the types of assets that you have, but to me it's also helpful to know the value for a few different reasons. One of those is to minimize taxes. So in Florida, we don't have a state-to-state tax, at least as of right now. Of course, things are all up in the air with politics right now, but we're going to disregard that for this discussion. So right now, Florida doesn't have state taxes, but we do have some additional concerns, like the federal estate tax limit, which again, it's so high right now that the majority of my clients are not meeting that threshold where we need to be concerned about it. But we do have those clients where it does, and with things changing, we like to know generally how much wiggle room we have if something does change. For other concepts like gifting and capital gains, like those are all things that go into my evaluation of whether we do a present transfer versus a ladybird deed versus a trust. Those are all things I need to have a little bit of an idea about. And the thing is I'm not going to waste your time explaining these really complex tax strategies and concepts if they're not even going to matter to you. First of all, you're just going to be confused, and it's already enough information with just the basic estate planning information I've got to give you. But if I'm throwing in these complex tax strategies and all this stuff that's never going to matter to you, A, you're going to be even more confused, and B, you're going to say, well, she didn't listen to me because none of this even matters to me. And again, that kind of goes into me preparing for your meeting. I'll have a little checklist of what I need to talk to you about based on what I saw in your estate questioning. Again, your assets are going to adjust the type of plan that I might recommend. Of course, I'm going to talk you through both options usually, which is a will and deed-based package versus a trust-based package. Those are usually the two routes that we go. If you have, like I said, you own a home, an average home, and have some bank accounts, I'm probably going to recommend a ladybird deed and a will-based package because there's no need for a trust. Generally, if you have a pretty simple estate, you're leaving everything to mature children or other family members or loved ones that are going to be responsible and not disagree to sell the house and all of those good things. If you're trying to leave the house to 10 different people, I'm probably going to recommend the trust because getting 10 people to agree on anything is going to be impossible in most cases. You might say, oh my gosh, my family's already talked about it, we all agree. When people die, family goes crazy. I hate to say it, but it happens so often that we see no issues while somebody's alive, but then all of a sudden when their family member passes, everybody has different opinions. Those types of things really adjust which route I'm talking, and especially if you have minor children. And I use the term minor children, obviously in the legal sense of both under 18, but also just young adults. We almost always recommend that nothing goes out right before 25, but of course it's something we talk through with you based on your goals and your specific family. I feel like a big reason why people don't disclose their assets is because they think I'm going to charge them more because they have more money. If that is a concern of yours, we have a flat fee sheet. At our office, we do all of our estate planning, primarily all of our estate planning as flat fees. That is a set fee that Meredith and I have sat down and gone through and said, yes, this is what we're going to charge for these, and it is set in stone and it's set there in our system. If you want that list ahead of time, ask for it. I'll send it to you and then you can fill out your asset information. The only time that I'm going to increase from that base flat fee is if you're getting more documents, essentially. Our trust includes one deed to put your one house that most people have into trust. But if you have 3 investment properties, we're going to have to do more deeds, so we add on to that price. If we're doing planning for minor children, our plan by default includes up to 2 children, but if you have 4 children, we charge a little bit more because we're doing like 6 documents per minor child. So there's a lot of things like that where it will increase the price, but that base price and the reasoning for it is never going to change. So again, if your concern for not disclosing information is that you think that we're going to charge you more because you are wealthier or have more types of assets, that's just not the case. And it's not just because you're wealthy that you automatically get a trust. We can still do an easy plan for you even if you have a lot of money. It just depends on what you want to happen and what your goals are. So again, in order to make sure that your plan is complete, your wishes are honored, your loved ones are protected, you're preserving your legacy, you really need to be honest with your attorney. And that includes at that initial consultation and during the homework phase of filling out your paperwork. By sharing all of those details with us, you're able to create a clear and effective plan that benefits everybody. We're saving some time during that initial discussion. And also it creates a much easier discussion because I know people's names. I'm able to use names. I'm able to say, if Johnny dies, then what do you want to happen? Instead of making it more abstract and difficult to talk about, I can really make that customized to you. And then during the drafting process, if you do retain us, it's pretty quick. I've got my questions answered during your consult. You've answered your questions on your questionnaire. I'm not going to have to follow up with you because we've already covered everything. So I can get your documents drafted much faster too, which everybody loves. So again, we can't help you if we don't know how to help you. So just always be honest with your attorney, always, but especially if in an estate planning context. So I'm going to stay on for a couple more minutes to see if there's any questions about this topic specifically, anything about estate planning. I'll try to help on anything else, but again, I primarily practice you have any other questions, please feel free to drop in the chat. So first one says, what if I or a family member generally forget something like an old 401k? What happens if it gets left out of my estate plan? It depends on what you did when you set up that 401k. Most of the time when you set up a 401k, IRA, Roth, anything like that, you are prompted to name a death beneficiary. So if there is ever a death beneficiary named on any sort of account, that stays outside of your estate plan generally, which is a tactic that we use in estate planning often. It's called a payable on death beneficiary. So if you have one of those names, it will automatically go to that person once a death certificate is provided, or they can roll it over to their own account depending on who they are. It's all the rules. If there is no death beneficiary named, we do have to go through the court process called a probate, where we say there was this asset that wasn't addressed. It will follow the laws of intestacy, which basically says that they didn't have a will, they didn't have a trust. This is who naturally it goes to under the law, which is generally your spouse, and then your children if you have any, and if not, then it just goes to basically your next closest blood relative. But we would have to go through probate, which we always try to avoid when we do estate planning, because why spend extra time and money to go through a probate when we can address it from the get-go? But things happen, and if you did do an estate plan and you did do a will, and you just didn't name that designated beneficiary on there, then it would follow the rules of whatever your will said. That's not the worst case, like, possible if you've forgotten something, but we do try to plan for everything. And then same thing, if things happen, if you get a new Roth IRA that you didn't have when you first met with me, you do get to meet with me for free once a year once you're a client. And we go through, hey, did you get any new assets this year? And then we say, okay, let's add this to your plan. What do we need to do to get this to go to who you want to when something happens to you? All right, so that looks like that might have been my only question that came through today. Again, thanks so much for joining me if you decided to join me today. If not, catch it on the replay. If you have any questions about estate planning generally, please feel free to give me a call or get scheduled for a consultation with me. And I'll be looking forward to filling out all of your homework so that we can have a good discussion and know exactly how to create a plan for you. I hope everybody has a good Thursday and a good weekend. I can't believe it's already September. But hopefully next month when you see me, I will have lots of new strategies and things to talk about, because Meredith and I are actually going to a big conference next week in this area. So we're looking forward to learning lots of new things and sharing that with you all. So I will see you next time. Bye.